Very cool. Well, I don't know that we definitely want to give people a few minutes to join, right?
Yeah, let's give them a few minutes.
Oh yeah, no, it does look like some people are joining. Fantastic. So December 1st, we've got a lot going on with Win Without Law School, setting up that launch, which is really exciting. And before we get into talking about how to tell your story to a judge, do you just want to explain what that is and what people can expect if they should register beginning in January?
Yeah. So, Win Without Law School is an amazing creation that Billy and I have brought, have manifested after, gosh, a decade or more of trying to figure out how to effectively help people representing themselves. Like, we get it, lawyers' fees are expensive. We're not just like, oh, $300 an hour, no big deal. I mean, it's a lot of money.
It's a
And
lot of
it really adds up. And when you're going through a breakup, be it a divorce, be it a custody situation, like, you're already strapped for cash because you had a household where you're combining your resources. Or maybe you've got a breadwinner, maybe you've got that dynamic. And now everything's changed and you got your own expenses, and it's like chaos. And then to add $300 an hour on top of that, like, yikes. And we get it, and we've wanted to help people, but finding a way to do that effectively has been difficult. It's the law is not straightforward. It's tough. Everybody's case is different. And technology hasn't been what it was, and online learning wasn't
Mhm.
such a normal thing. And so we're at this time now where people are used to learning online, and a lot of people are going through some really tough relationship stuff. And so if we can empower people to get themselves to a place in their family dynamic that is so much healthier, and do it in a way where it's like the ultimate empowerment tool, where you're literally going into court and telling your story and representing yourself. And if you can do that and have success, like, wow, I mean, how much more does that put you on your new path as you're leaving this relationship and finding your new identity? I mean, it's a really amazing opportunity that we want to create for people. So that's the basis of Win Without Law School. And what we're doing is we're launching an education platform to share what we've learned about Arizona law and family law and courts and judges and dynamics between spouses and co-parents, and making it as easy to understand and as user-friendly as we can. I mean, Billy, can you touch upon that, like the challenges over the years of trying to help this group that is the majority of people going through the court system?
Yeah, I absolutely can. It's interesting you brought that up. Man, I mean, you're right. So when I first started modern law 13 years ago, it was to help people who were representing themselves, because that's the largest market of family law litigants. Most people going through court are representing themselves, which meant I saw that as an opportunity to help them, and also a business opportunity that the lawyers had not addressed. And because of regulation, only lawyers were allowed to practice. That's changing. And I've tried a lot of ways to reach this market, never really making a dent. There were a lot of people I helped, but never like on a large scale. And I love Win Without Law School because it is teaching with enough specificity, with enough resources online, but also feedback. And so it's the full package. You're getting live teaching, you're getting recorded materials, you're getting documents you can use, you're getting a community that can support you. I am so excited for this, and I really hope that this is the thing. But I also know that I will just always continue to listen to this market and figure out how to respond to people who are representing themselves, because I love you. I see you.
Yeah, I've seen so many people struggle in court representing themselves. These days I don't go to court that much. We're able to do stuff by phone. I mean, things have changed a lot, but early on in my career, I was in court all the time.
Mhm.
And I can't tell you how many hours of my life I've spent waiting for my case to be called, because they do
Right,
these cattle calls. They
right.
set, 50 cases at one time, and you just sit and wait until yours is called. I mean, I'm exaggerating a bit with 50, but you get to watch a
Mhm.
lot of stuff that happens in the courtroom. And I would see all these self-represented parties coming in, and man, was it tough. And when the first year I was a lawyer, I was out in small town Parker, Arizona, and I worked as a prosecutor. But when you work in a small town, you do everything. Okay.
Mhm.
They have limited human resources, and you're doing it all. And I was assigned to handle the child support division. A lot of counties have given that task over to the Attorney General's office, and
Yes.
La Paz County has actually done that since. But when I was there, La Paz County still did it on its own. And we
Wow.
had a staff of like 4 child support caseworkers, non-lawyers, staff, and I had to manage them, and I had to go to court and do every single child support case that came through the county. And it was almost all self-represented people. So I would see them, and people come in, they don't know what an AFI is. They don't understand service. They don't know what they're supposed to do. And some judges are really accommodating. Others are mad, and
Right,
they get mad that you don't understand these things.
right,
And my heart would just break, because I'm like, I know the answers and I'm not allowed to tell them.
right.
I can't do
It's a pretty
anything. And
awful
I'm just
system.
like, oh, I want to go tell them what to say and what to do. And I couldn't do anything because they're not my client, and it was inappropriate. And so I just had to sit and watch them struggle.
Yeah, yeah.
But, Win Without Law School is going to take somebody who wants to put the time in.
True.
It's not just going to be you join and then poof, like you know what to do.
Right.
We're certainly trying to simplify it, but it's going to take some effort. And I know there's a lot of people out there who are willing to put in the effort.
I agree with you. I have watched people effectively represent themselves. You have to put in the work. You have to be organized. You have to get educated. And this is just going to make it easier for those people who want to put in the work and help them go from where they're at right now to better. And don't think for one second, that all of us can't get better, because we can. I am always working on getting better. Julie's working on getting better.
Yeah.
People who have represented themselves who are still stuck in family court can get better. And that today is about telling your story to a judge. So how can someone effectively tell their story? One of the hardest things is, what does a judge actually want to hear?
What often happens is people go right to the emotional stuff. He did this, she did that, da, 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 da. And there's really no tie to the law. There's no chronological storyline.
Right,
There's just this emotional dump.
right,
And the judge hears this stuff day in and day out, and it's just like in one ear out the other. And they're like, okay, well, why is this best for your kid? The judge is trying to get it into the law stuff, and they're like, oh, but he's a horrible parent. But just using these generalities and this name calling, that does nothing to help the judge, because you need to tell a story about what happened. It's the facts that are really the most persuasive part of a case. And the challenge is that there's a million ways to tell a story.
right.
And so what do you highlight and what do you leave out? And that's, as lawyers, what we are so good at. I want that fact in, and I'm going to highlight this, and I'm going to really try to ignore this thing.
Minimize that.
And so, that does take some inside knowledge, but that's the goal, is to find a way to tell the story that really highlights the things that matter.
Right. Yeah. And it's hard to know what are exactly the things that matter, but there are some things that everybody can do to become more effective at telling their story. And Julie touched on the fact that you need a lot more background generally, but the background that they need is the facts, what happened and when, the highlight, the timeline, the like, if you were in a history project in 5th grade and you built a timeline, it's almost thinking about it like that. Like, what are the critical events that happened that led to this particular hearing? Now, one of the things that you were going to talk about is knowing what is the hearing I'm going in for, or what is the motion that I'm arguing, so that I know how to tell my story.
Some people think that, you know, especially self-represented parties, they think at every hearing, it's like time to give a closing argument. But it's not. There's a time and place for a closing argument. And so understanding the procedure and what's going to happen at each hearing is really important, because if you don't understand that, you could come away feeling like you got gypped, like the judge isn't hearing you and you're getting the short end of the stick and you're not being treated fairly, when really it's like, no, this was a resolution management conference. Like, I don't want to hear any facts. I'm just here to see where you guys are at. And are you going to go to mediation, or do we need to set a trial date? Like, the judge doesn't want to hear anything about accusations at what they call an RMC, a resolution management conference. And so if you're going in and being like, oh, but he or she, da, 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 and the judge's like, you may think that the judge doesn't like you, or that, you know, the system's against you, but it's just, no, you haven't brought your issue to the judge in the proper way to get that thing heard. So you're going to need to understand what type of hearing you're going into and prepare accordingly. That is probably one of the biggest challenges for self-represented parties, because even if you're like, oh, well, it's an RMC, well, okay, you know, what does that even mean? You need more information than just the name of the hearing to understand what happens at that type of hearing, and then understand like what is expected of you.
The RMC is a great example because it is set in every case, and it's supposed to be non-evidentiary and non-argumentative, but people can be left very frustrated when one party spends that time arguing and testifying, and a judge allows them to and doesn't cut it off. And it's the case's first impression in front of a judge. And someone can be left feeling very, very frustrated if they didn't get to say their response to those accusations. What do you think about that?
It's interesting. I have not seen that at an RMC. Don't know why, but I have not seen that. So yeah, that would be tough. That would be really tough. And, you know, sometimes it just feels like it doesn't go right. But you also have to remember that the judge may or may not actually remember those arguments that were made that day. Like, is it really going to change the outcome of your case? Possibly. Or it could just be another day and the judge heard 50 other things. And between now and the time he sees your case again, he's heard 1,000 other things and this meant nothing and he doesn't even remember. Don't know. But, you know, that's just where, if you understand the context of the hearing, you may be ready to make a really powerful objection and say, Judge, objection, this is a RMC.
Right.
Let's talk about scheduling. Stop slandering me.
Right. I love that. You know, I love that because you have the ability to stand up for yourself, to make your point, to say, Your Honor, I know that you don't want to hear my rebuttal to all of those things, which I do not agree with, because we're here for an RMC. And this is what I'm asking you to do today at the RMC. Like, that is powerful.
Mm-hmm. And I can see a judge being like, you're right, let's move on.
Right.
Okay, what are we doing next?
Mm-hmm.
And this is the thing that so many people don't know, is the judges are rooting for the self-represented parties. They want them to do well. Like, they want a smooth experience with these self-represented parties. And I've seen judges help self-represented parties to no end. And so if you can come in and you're prepared and the judge is like, wow, I mean, the judge may want to help you even more. So getting this information and being part of Win Without Law School could be really valuable. Okay, so understand the type of hearing you have, prepare for that. And then let's say it's the type of hearing where you do get an opportunity to tell your story. It's some sort of evidentiary hearing. Okay, it could be on a motion for temporary orders. It could be a final trial. It could be an oral argument on a contested issue. Always remember that the judge has hundreds of cases. You need to know that this time you have with the judge is really important. And when you talk, you need to make it so that it's something that the judge is going to remember. I'm not saying it needs to be catchy. I'm not saying it needs to be like something totally polished, but it needs to be something that the judge is going to be like, oh yeah, they have a daughter named Sarah, and Sarah is 7 and she has special needs. And because of those special needs, I really need to pay attention to a few things in this case because Sarah has special, like you
Right.
need to make things really clear for the judge about why your argument is important.
Right. What is different about my story? What is unique about my story? How do I not become lost in the sea of all of the other divorces? And then, I mean, unless you have an uncontested divorce, and then maybe that doesn't matter and you can be lost in the sea. But like, if you really have a contested issue where you need a judge to make a decision, then you need to not be lost in the sea. And you have to give enough background. Many times it's easy for us to jump into our argument, assuming that the judge feels the same way about the past and about what the facts are as you do. So you might lay out the facts and then have a conclusion in your head and expect them to jump to that same conclusion. So going back to what we were talking about, you're making the timeline, right? You're dropping the facts, but then you also have to spell out, and these facts mean X for my case because my case is special and here's why.
Right. And I also like to create a visual for the judge. So let's talk about custody, because I'm sure that's, what is one of the most common case types of our audience. Pictures of the child's room, just showing what life is like for the child with me. Like, this is the life I can provide this child. And it seems very simple, but again, the judge has hundreds of cases, and now the judge has an opportunity to see a picture of what, Sarah is one of our co-hosts here, but I use the name Sarah for the child, what Sarah's life is like with mom or dad, and then it could go further into other stuff too. But, individualizing your case can be important. And it could, and just having that as a guide as you're creating your case, I think can be very helpful.
Yeah, I totally agree with you. And it's hard to know how much, right? You don't have time to flip through your entire photo album, your entire baby album. You won't have time for that. But you do have time when you're talking about the best interest factors, when they're asking you, what can you describe your relationship with your child? If you say, we worked on this project together and I'm so proud of him. Like, look at what this child did. And he got 100% and we did it together. And that was great. That was one of the things we like to do. We also go to the movies. We do this, we do this. Like, now when the judge has to make findings, he has to think of something to say, or she, in the ruling. They don't have an option. They have to put something in, and you've given them something to put in, as opposed to just, mom said it was good.
Yeah. And that's such a key point, is starting with, this conclusion of what you want to show, and then identifying those facts that illuminate that point, and then testifying to those or eliciting those on direct examination, or having an exhibit that, illustrates the point you're making. It's just, if you're just going to get up there and go on and on and on, oh, and then the dog barked, and then I opened the door, like, the judge is human. The judge is going to tune out. Like, we're all human. And so engage, tell an engaging story. And it's not that you have to be some expert storyteller. It's about crafting your story around compelling facts.
Yes. So what, and this is hard. So what I think you need to do when you're thinking about telling your story, first figure out what type of hearing am I going into? And then ask yourself, what decisions is the judge going to be making? What is on the table? What decisions is the judge going to be making? Then ask yourself, what do I want the judge to decide?
Yeah.
Then after you know, so let's take the custody example. I want the judge to order my child stay with me during the week and have weekends only with dad. If that is what you want, now you know what you have to prove, and now you know the story you have to tell. And then you're going back and you're finding the applicable statutes, and you're determining what evidence in my story meets the elements of this statute. So it's a very systematic way to figure out how to tell your story.
Yes. And this, like Billy, what you just explained is the step-by-step process that we take as lawyers when we prepare for hearings.
Right.
Right? Okay, what type of hearing is this? Okay, all right, what do I want the judge to do? Okay, how am I going to get him there, him or her?
Right.
And that's what you've just laid out. And that's what Win Without Law School is going to teach in a more in-depth manner. Showing, okay, here's the statute, like taking you to those places in the law to help simplify it. But that is so true. And a big question to always come back to is why, from the judge's perspective, why should the judge rule for me on this issue and on that issue, on the parenting time? Why is this best for our child that my proposed parenting plan go into place? Why should we have joint legal decision making? All of those things, that could be a really good starting point if you're like, I don't even know where to go with this. Oh my gosh, there's so much that's happened.
Right.
Okay, let's break this down. Why? Okay, what do I want? What am I asking the judge to do? And then why is this best for our child or children? And then how do I, what events illustrate that? So if, for example, let's stick with what Billy said, with mom during the week, with dad on the weekends, and your mom, talk about the structure. I would even create a one-page exhibit that had a general week of what it looks like at my house. It would just, an Excel spreadsheet, I'd have the times, the days, kids are in school, this is what we do, then we do homework, boom. Now the judge has one document that could take a half hour to explain, but now it's boom, it's there. Yeah, this is what we do every week, and this is when we spend time, and we exercise here, and we eat well here, and they go to bed by here, and their homework's done, and look, oh, and then exhibit 2, here's their report cards. And here's when they were spending more time with dad and what their report cards look like. And now that we've got this really nice schedule in place, this is what, that's going to prove why the kids being with you during the week is best for them. So now you're not just like, well, dad doesn't get them to bed on time, and and it's not just all these accusations about dad. It's now changing it to the kids and why this is working so well for the kids. And of course, you can throw those jabs in at dad along the way, but your whole presentation isn't just now dad sucks. It's like,
right. Or
deeper than that and more detailed.
Right. The more you can humanize your kids, if you're arguing for that you keep your children during the week, you need to know what an uphill battle you have, because culturally and philosophically, judges want both parents involved in all aspects of parenting, which, that's not exactly how intact married couples function. It is not unusual for intact married couples to delineate roles, but the culture has judges really moving in a direction where they want both parents to have the opportunity to do all of those things. But if you can talk about how dad having the child on the weekends is the best for the child, because here are the things dad does with the child on the weekends that the child really loves, and here's the things that mom does with the child during the week that the child really loves, and how this really serves the child's best interest and maximizes the strength of each parent. Ooh, like that's a compelling argument.
Exactly. All right. I think we've covered that point pretty well.
Yeah.
The next point is related, but it's a little bit different. And it's to when you go into this contested hearing where you have the opportunity to tell your story, pretend that the judge, like you're meeting the judge for the first time and the judge knows nothing about your case, because you're going to tell your story in a more detailed way if that's the approach, because you're not going to be like, oh yeah, and then they went there and she said that and I did this and he made that, and the judge is like, well, who's he, them, there, where? You really need to be specific with names and explaining, you can't just start talking about Mimi and not explain that Mimi is the paternal grandmother or Mimi's my mom. You need to lay out who Mimi is. Otherwise, the judge is not going to really be listening to you and instead be thinking, who's Mimi? Who's Mimi? And not really be hearing the rest of the story.
Right.
So you need to lay that background about who each person is and have that support the whole story. Otherwise, there's going to be a lot of holes in the story and the judge is going to be confused.
I think it's important to note that people underestimate the amount of time it takes to write a good story. When I am representing a client and I'm writing a pretrial statement or a motion, and I'm doing my best work, I'm going back and rewriting that 3 times.
At least.
And does that take a lot of time? It does. But if somebody's relocation's on the line, then me making a chart that compares, life in X place versus life in Y place and all of the characters and all of the locations, and then cutting out anything that doesn't serve the argument. It takes a lot of time and effort, and it is worth it.
And this is the thing, your case the best. Like for us, we're constructing somebody else's life and, trying to piece out the details and call it, oh, but then what happened then? And, we're like doing all that stuff. Like if you're representing yourself, you already know all of this stuff. So that is very helpful.
And one of the best things you could do, if you're on our Facebook page, that there are 1 million people in here going through the same thing you are. Not 1 million, but 850. Find somebody that you're not friends with. Ask them to read your story. They don't know you. They haven't heard about it day by day, detail by detail. Let them read your story and ask them, what did you think after you read my story? Did you feel like there were any holes? Because the judge is that person. He or she is a stranger. They don't know you. They don't know your kids. They don't know your case.
That's such a good point too, because if you're really angry, you could write a story that's just so biased.
Yes.
And so uncompelling because it's just you, dumping all of your emotions.
Yes.
The pretrial statement is not your journal.
No.
And so having somebody else read it could be really helpful to, address tone, address, angling arguments. So it's less throwing mud at the other side and more artfully throwing the mud so that it's more positioned to support the law and what's, on the table. So I think that's a great idea of having a neutral, total outsider read it to see if they're like, oh, you come off pretty bitter here. Or if they're like, oh no, I was crying. You got to win this case. Your kids have to be with you. I'm sold. What is the response?
Right. Same thing when you're asking your questions of your witness, like letting somebody who has not heard your case before hear that will help you determine, did I leave gaps? Because it's easy to leave gaps when you're telling your story to the judge.
Oh, definitely. Yeah. You don't even realize it. And
right.
Then somebody else is like, but wait, how did you get from 2015 to 2020? Like what happened in those 5 years? I'm confused.
Right.
And you're like, oh, nothing. That's why I left it out. Nothing happened. It's like, well, still, at least say something about it because it's confusing. It sounds like you're trying to hide something.
Right. Right. So we do want to leave time for Q&A. Do we have any other points on telling our story?
There's one final point, which is if you can, look to identify 3 to 5 major points you want to make and craft your story around that. And then once you've got your story figured out, tell your story over and over again. You know, that's kind of how it goes, is you want to be consistent. If your story keeps changing, I mean, I know new things happen, but if you're changing a past story that you created, that's going to create, you know, red flags in the judge's mind. So you got to stay consistent.
That's a great point. If you go back and watch our past Facebook Lives, we've talked about creating a theme and theory for the case. We've talked about how you're telling a story, and these stories involve characters, and how you need to be in character and tell that story consistently at the same time. So definitely, go back and watch those. If that's something that you're having a hard time figuring out, well, how do I come down to 3 to 5 points? You know, if you've got your theme and you've got your theory and you know what you want, then you can really come up with the 3 to 5 points. The other thing I would again tell you that is helpful is sometimes letting an outsider read something and then having them tell you, this was what was most critical for me. That can be very helpful, because something that you might not think is a big deal could be like a real thing to focus on.
Yeah, definitely.
So let's see, do we have questions, Sarah? I know we do coming in on TikTok, but I wanted to answer the Facebook ones first if we have them.
Sure. So Brianna, you had a list of questions for Billy, right? We haven't gotten any questions from this group yet. I'll let you know when we get some.
Got it. Okay, then I'll move on to the TikTok questions.
Okay.
All right. So how do you word abuse when he tells the kids not to say anything?
Can you say that again? How do you?
The comment says, how do you word abuse? But I think what we're saying here is, I think if I'm reading between the lines, what you're saying is the kids have disclosed to you that they're being abused or mistreated, and they have told you, they have sworn you to secrecy and said, do not say anything. And maybe you've committed to not saying anything because you want to create animal abuse. So apparently the kids have disclosed animal abuse in one parent's home, but said, please don't tell. What can she do about that?
Okay, so I want to give a couple disclaimers first before we jump into this. Billy and I don't become your attorneys by being on this Q&A. We're giving legal information. This isn't legal advice. Legal advice is one-on-one, where we sit down and really get into all the in-depth. This is just general information. And we are both licensed to practice law in Arizona. So this is based on Arizona as well. Okay, so this is a tough one. I generally want to try to create a situation where the parent who is getting the report is not the one making the accusation.
Right.
Because
you have to find a way. I mean, I completely agree with you. Like, if you as mom have been sworn to secrecy and you want to protect that with your children, you kind of got to convince them to tell somebody else, right?
Not only that, but I feel like if you come in and start accusing your ex, it's just going to turn into this denial and, oh, you did, like, I think it's just going to be this he said, she said. And then maybe they make some changes and they aren't abusing the animals in front of the kids, or maybe they keep doing it worse and are like, you know, mind manipulating the kids more. But I feel like if you come in and make the accusation, it's going to be met with a lot of resistance. But if a government agency comes in, or, you know, a neighbor reports, or a teacher, a mandatory reporter at school, you know, then it's a whole different situation that you don't have your hands in, and it's going to unfold the way it unfolds. I would also look to put the kids in counseling if you can, because if they start reporting to the counselor, that can be a whole different thing. And also, if they have been exposed to animal abuse, they should get some sort of counseling, because that's very traumatic.
Absolutely. Absolutely. That's great stuff. Okay. So another question that came up on TikTok that I think is such a good question. This person is going into a temporary orders hearing, and she is being accused of having mental illness and therefore not being able to take care of her children. And she says that she is in counseling. And so I want to address this, not just with mental illness, but this is the same situation. If you've been accused of being an alcoholic, if you've been accused of being a drug user, or if you've accused of being
Physical
mentally
abuser.
unwell, physically
Yeah.
abusive, like, and there may be some truth to it. What do you do?
So first of all, I would be getting into the facts.
Mm-hmm.
Because this just, I'm being accused of not, being mentally ill. Well, that's very broad and that's hard. Yeah, how do you defend against just mentally ill? Like there needs to be some sort of factual allegations that they're making to support that blatant allegation. So that's what you're going to be wanting to create or find counter evidence to and really focus on in your case. So those however many instances of bad acts that they're claiming you engaged in that are proof that you're mentally ill, do you have evidence to counter them? Do you have an explanation? Do you think it's not true? I would be looking to break down and refute as many or all of those if possible.
Yeah.
The other thing is being honest.
Right.
If there are some of those instances where you did mess up and it doesn't look good, I wouldn't be coming in and trying to minimize it or it did, like, because that can really rub judges the wrong way if they don't think that, you're really taking accountability. But if you can come in and explain a little more detail about what happened and how you learned from it and you won't do that again, I mean, you're going to have to, again, you should get specific legal advice on this. This is a pretty difficult area. But I find that can be better because if it happened and it's true. If you come in and you're just trying, oh, well, it wasn't that big of a deal. And, oh, the kids are fine. Like, that doesn't look good. But if you're like, you know what, it was bad and I messed up and I'm never going to do that again. And I'm sorry. I think that can be better. But again, you really have to, I'd have to know the exact facts. I'd have to know a lot more to explain exactly how to handle these types of allegations.
Yeah, these are very serious cases where you're being accused of, being unable to take care of your children, or an alcoholic, or, let's say, I mean, and there's so much of this right now. Sometimes someone will know that they are having a mental health crisis and then check themselves into an inpatient treatment facility. And that in that case, like you really, really, really have to talk to a lawyer, because we can help you figure out how to address that. And it may be that you can address that by saying, really what I was experiencing wasn't that big of a deal. It never negatively impacted the kids. I always made arrangements for them to be fine. And I just wanted to be my best self. And this was how I got myself there. And it's never negatively impacted the kids. And as long as if that's the truth and you can lay that out, then the fact that you went to a mental health inpatient treatment center should not in and of itself be a problem. If you attempted suicide in front of your children, which is something that I have seen, you don't want to minimize that. You don't want to minimize that at all. That's hugely, horrifically traumatic to your children, even though I know it also was awful and traumatic for you. But in court, the court doesn't want to hear about how awful it was for you and how you were. They just don't. They want to know how are you going to take care of your children? So these are very difficult situations. I completely agree with Julie. The advice totally depends on the facts and the circumstances and what happened, not just mental illness, but what happened that's leading to the allegation. Because in and of itself, let's say that the allegation is simply you're mentally ill, you're taking antidepressants or anti-anxiety medication, which happens, that comes up. I think something like 40% of the population is taking anti-anxiety or depression medication. That is a non-issue in family court. That in and of itself is a non-issue. Have you seen that as well?
It doesn't even come up. Yeah. I mean, I don't see it being it's more extreme allegations, but yeah, just the taking of the prescribed pills, like that's just kind of run of the mill.
Right.
It's not anything that, now, if you're abusing them, Adderall is an amphetamine and it can be abused. That's a different situation. But if you're taking an antidepressant according to how it's been prescribed,
Right.
good luck making any big deal out of just the fact that they're taking the prescription alone. Like that
Right.
alone is going to mean nothing.
Right.
I think another angle to this is, you know, an event happens, and by the time a judge hears about it, there can be months that pass. You know, there could be an emergency temporary order that brings it to the judge's attention immediately. On the flip side, there's, you know, a lot of situations where there could be 6 months or more that pass between the horrible event and the judge, you know, making a decision about it. So what are you doing in those 6 months to position yourself to look better? Because if you were like, it was no big deal and nothing's happened since and I'm fine, that's not believable. But if you're like, I started counseling, I started family counseling with the child, and here's some counseling reports, and I don't know, I'm doing all of this wellness stuff. Like I'm in anger management, I'm in Alcoholics Anonymous, you know, like the judge is going to start to kind of want to be your cheerleader, like support you on this wellness path. But if you come in and you're like, oh, everything's fine, I don't need counseling, like the judge is gonna be like, oh, I don't trust you.
Right. Right. And a lot of this is like, one of the things that we do in these cases is we evaluate, like, well, how does the judge feel about you today? We can usually tell by the orders, and then we can decide, okay, you need some rehabilitation in front of the judge. And that might mean you cannot drink, or you have to sign up for SoberLink and proactively demonstrate that you are sober during all of your visits, or you need to be drug testing even though the court has not ordered you to, because you're eliminating that possibility when you get to trial, that you know, dad says mom's a drug user, and mom says dad's been saying this for a year and I don't know where he gets it, and here are my tests. That is effective. That is much more effective than, you know, saying nuh-uh. But so sometimes these accusations are completely and wholly unfounded and untrue, and other times there is truth to it. And if you don't face what's going on and deal with it head on and address it and be honest about it with the help of your attorney, to the extent of your honesty, you can have a really hard time rehabilitating yourself in front of a judge, and you can end up in a very bad position in family court.
I want to touch upon this for a moment from the other side, from the person making the accusation, where it's a valid accusation and they have concerns about the safety of their children. One fallacy I often see is the parent doesn't actually gather the evidence. They'll be like, oh, I didn't ask her for because I knew she'd say no. And it's like, well, you can't go into court with just this speculation.
No.
You need to have actual evidence. And so don't just, oh, I know how they're going to respond, so I'm not even going to try. Like that's not compelling in court. So you're going to need to be a bit more proactive with gathering the evidence to show that this is the true way that this person is. Also, you know, if you're the one with the concerns, there's some recent case law that those, you know, if the person's gotten any sort of psychiatric treatment or counseling, those records are fair game to get through disclosure or through a subpoena. So you actually can dive into these mental health records and seek to use them in the case. And then also remember that the evidence is going to be really focused on the children. So despite any bad acts between you and the co-parent, if those don't happen or affect the children, it's not, it could be important still, but it's not going to be as compelling to something that's related to the children. So just remember to always focus your arguments around the children and how mom or dad's erratic behavior is impacting them.
And let's just highlight what Julie just said, erratic behavior, not possible diagnosis. So I see a lot of people who want to prove that so-and-so is a narcissist. Doesn't matter. And maybe,
Right.
so maybe you've read up all about narcissism and all about coercive control, and you know in your mind that that should be enough. That's your position. A narcissistic parent who's, formerly had XYZ behavior cannot be a good parent, and therefore that's all I have to prove. Understand that the legal system isn't there, isn't with you, is not on the same page as you, doesn't want to hear it. Does not want to hear it. They want to hear, how has this person's specific behavior that happened on XYZ events affected your specific children? Your specific children, because some children are highly affected by yelling and discipline, and other children are not. And they can live with a parent who yells and be fine. And some children are shutting down and unable to perform in school and experiencing anxiety because of behavior that other children might not, experience that way. Like, it's important for us to tell the specific story of the characters involved.
So Billy, if you've gone in and you've told an effective story, you don't need to say the word narcissist.
Right.
The judge is already thinking it.
Right.
If you tell an effective story and you highlight 3 to 5 examples that scream narcissism, you don't even need to say the word.
Right. Right. And that is a much, much, much more effective way of getting the judge to do what you want him or her to do. One question we've got here is, what if the other party who's unrepresented is lying about things and no evidence is present, and it makes me feel on the defensive to try to make the judge realize I'm not this person? So we need to talk about discovery, I think, and when you're representing yourself, how much work it is. You can't just go into court without evidence. And that goes up both ways. Like, you have to gather evidence both ways. If somebody's accusing you of something, you have to gather evidence to show they're wrong. You can't just go in and say, nuh-uh.
I mean, you can, but
I don't recommend
it's
it.
not going to be as effective, because now you've got a he said, she said. And again, think about your judge. He said this, she said that. I don't know these people.
Right. So if there's accusations that you are, that you were fired from your job, or that you are, unstable or whatever, you're going to have to be prepared to show the judge it's not true. I am stable. And maybe I did lose this job, but I got this job, and people lose jobs, so you have to address the accusations, which can be so frustrating sometimes, because you're there to talk about something, and their strategy might be just to hurl accusations, and you have to address them.
And actually, what I've found is the people that hurl the most accusations are the ones who are doing the worst stuff. And usually the accusations they make are actually the things they're doing. And so it creates a lot of problems, because you do have to defend against the accusations. Okay, you can't just let it stand and be like, oh, but that's not true. The judge isn't going to believe that. Well, you need to show the judge why. And I've encountered that a lot, especially with people who are kind of naive and are principled, and they're just like, oh, but that's nonsense, and they'll know. And it's like, well, we need to show that that's not just accepted.
Right.
And so, it's this delicate balance where you're defending while also making accusations. So it's defense and offense back and forth. And in law school, they called it the shield and the sword. Do you remember that?
Yes.
You're putting up the shield and defending, and other times you're, striking with the sword, and you're going to have to do both. But this is where you need to break it down, okay? Because it can get really confusing if you have 5 different accusations lodged against you. First of all, identify the 5 and figure out 5 reasons why it's a no, and try to simplify it as much as possible. But this is where you really need to tune in and separate emotion from reason, because you can get just buried in the emotions of this, because this has likely been the dynamic between you and this co-parent. You know, this probably isn't the first time they've made accusations against you. That may have been one of the reasons you split up. And so you likely have this set pattern where you go into scared, defensive mode. That's just like out of fear. It's not a calculated, reason-based, law-based argument. And that's where you're going to need to take that deep breath, let some of these emotions go, and focus on your judge. I tell my clients this all the time. When we get in the courtroom, who cares about the other side? The judge is the decision maker.
Right.
I don't care what the other side thinks. I don't care what the other attorney thinks.
Right.
The judge is all I care about. And it's the same thing that you should care about. So it doesn't really matter what your ex is saying to you. What does the judge think about it? And what do you need to show the judge to convince the judge that these things aren't true, or that you are a good parent, or whatever the accusation is?
The other thing I want to just say that we've said over and over again that I'll never stop saying is that litigation and family court and taking your case in front of a judge is not recommended. It is not the best move most of the time. And the consequences are not just, let's say you win. You've still damaged that relationship with a person that you have to continue to co-parent with. If you can find a way to mediate and to come up with something you can both live with, you are creating a more peaceful relationship between the two of you, which absolutely does spill over to your children. So I'm not saying give away the farm, but I'm saying give mediation an opportunity to work and be willing to show up day after day and be open to changing the dynamic and coming up with new solutions. I know it's hard.
Do you think we have time for one more question?
I think we do. Let's see. So yeah, one person saying this person keeps saying no to mediation. Just keep asking. Just keep asking. One question that I've got here is there's a 50-50 parenting plan. And when the kid is with dad, the child is a kindergartner, dad lives 25-ish minutes away, and the kindergartner is tardy a lot with dad. And mom doesn't think it's in the child's best interest to have 50-50 or live with dad because of the tardies. There's not really a question. I don't know.
I mean, I don't think it's enough to take to court. Just the tardies for especially a kindergartner. If it was a high school with tardies, that could be a bit more compelling. But for kindergarten, I don't see you getting very far with just that one point. And this is what's so tough about co-parenting, is you have certain expectations and ways you want things to go, and your co-parent isn't necessarily going to agree, and things may just have to be a little sloppy for a little bit. And it's kindergarten. But maybe with time things can shift, and people move around, and the school's going to be in a different location, and maybe it's not 25 minutes away. And
right, like you things are not going to be perfect. You got to kind of lower your standards when you're co-parenting, because things are not going to be perfect, and you've given up control. And some acceptance helps with that. There's a really good question we got. At what point does discovery begin? Is it when there's a requirement for the opposing side to provide medical records, or does it begin before filing? It's a great question.
So there's 2 pieces, if we're going to be technical. There's disclosure, and there's discovery. They're similar, but they're a little bit different. So disclosure is controlled by Rule 49 of the Arizona Rules of Family Law Procedure. And Rule 49 lists out all of the information and documents that each side is required to share with each other. And Rule 49 says that this obligation starts 40 days after the response to the petition is filed. There are some different rules for post-decree matters. So I'm really focused on like a child custody establishment case or a divorce case. But Rule 49 lays out, bank statements, credit card statements, real estate deeds, and then things related to children too are listed in there. So each side has an obligation to exchange a certain amount of information per Rule 49, 40 days after a response is filed. You have a continuing duty of disclosure thereafter. And part of the disclosure is all the exhibits you want to use, like the list of witnesses and their, a summary of their testimony. And then there's discovery. And discovery is where, okay, the stuff within Rule 49 isn't everything that I want from the other side. There's actually some additional documents that I want. Well, you can get those through what's called a request for production. Or maybe there's certain facts that you want to see if they're agreed to or not. You can do a request for admissions, asking the other side to admit or deny certain factual allegations. There's what are called interrogatories, and there's a set of uniform interrogatories that are like 50 different questions that are these set questions related to family law that can go out, and you're supposed to tailor them because not every question is going to apply to every case. But you can send those out and ask the other side to answer, or you can do non-uniform interrogatories where you create your own special question. So discovery is something you have to propound, you have to send out on your own and ask the other side to respond to, or the other side can ask you, serve you with a discovery request. But if neither side serves a discovery request, then there is no discovery that's taking place. A deposition, is another type of discovery. But the disclosure is required by both sides. And so if the other side hasn't provided the proper disclosure, you can get the court involved. But when does that start? That starts 40 days after. I mean, as far as gathering it, you can start gathering it before then. That's helpful. Any other thoughts on that, Billy?
Well, I mean, honestly, we could spend an hour on disclosure and discovery, and we should. It's a super important topic. There are some other questions about CAAs. That's also like, we could do an hour on TI, CAAs, COBIs, and we should. But we are out of time for today. So Brianna, when is our next live?
It's on Wednesday at 11 a.m.
Wednesday at 11. Okay, so many of you, I apologize that we didn't get to your questions, but I have another meeting, so we have to go. Julie probably has another meeting. Wednesday at 11, tune back in. For you TikTokers, make sure to join the Decode Your Divorce group so you can see it online and ask questions there, because I don't always see them here. And thank you all for being here. Thank you, Julie. Thank you, Sarah and Brianna.
Thank you, guys.
Thank you. Also, if you want to join our email list, go to winwithoutlawschool.com/home, and it'll take you to an email sign up. So go there, sign up for our email list. We'll have more information about Win Without Law School. We're going to open registration this month, and classes will start next month. So if you are interested and you need help with your case, please sign up for our email list.
I am so excited about this class. I think it's going to make self-representing just go to the next level. So absolutely go sign up. We can't wait to start. Thank you all, and we'll talk soon.
Thanks, guys.
Bye.
Bye.